Hi, I'm Michael Salter and welcome to this 42 Bedford Row Employment Group webinar on multiple respondent claims. This is a re-recording of the webinar I gave on Tuesday the 30th of March. Those of you who attended on that date will realise they were beset by technical difficulties in PowerPoint. Firstly, my slides didn't show, and then when I got that resolved, the problem arose that I was locked out of my notes and my presenter view didn't advance in any way, so I was having to work out from another screen what slide I was on and do my best to remember the points I wanted to make. It was I guess the pandemic's equivalent of one of those anxiety dreams that when you turn up in court, you open your folder to realise you don't have any notes on your case, you've got a very angry judge, and you can't remember anything about the case from off the top of your head. Also in those dreams I'm not wearing trousers. I can thankfully reassure you that when I was giving the webinar I was wearing trousers. Now this is the 7th in the series of webinars by the Employment Group where we've tried to aim and look at practical issues that arise in employment tribunal litigation. So we've dealt with social media claims, we've looked at how to prove disability, protected interest disclosure, interim relief. And we've also presented a series of webinars for specialist employment practitioner groups, including a local authority consortium. So if you have any suggestions for a webinar that you think you and your team will benefit from, please do drop us a line and we'll do what we can to facilitate your training needs. So what we're going to look at today in the course of the webinar are the examples of claims where multiple respondents can be named. Equally, further, we're going to look at how named individual respondents can be parties to the litigation. We are going to touch on various tribunal rules and case law, and then look at practical tips for claimants and respondents, what they can do to maximise their chances of success. I'm then going to have a brief run through how the Equality Act and the Employment Rights Act deal with multiple respondent claims, and then look at the employer's defence and the employee's defence. When I was planning this webinar, I spoke to Jill Crew, a member of Chambers, and she suggested that every slide should have a curious owl. So here's today's curious owl asking the question, why? Why would you be involved in tribunal proceedings that involve multiple respondents? Well, there's a large number of cases or situations you might find yourself in, for instance, under TUPE, where there's a transferor and transferee. Following on from that, where there's a dispute as to who actually is the employer. Where you might want to join the Secretary of State in insolvency proceedings, or a trade union who's exerted pressure to dismiss a non-union member. The tribunal rules themselves, Rule 35, allow for non-parties to be involved, and there's cases where there's representative respondents, most obviously where there is a unincorporated association, and you should normally sue them in the names of all the members of the board. However, often one party steps up and is a representative respondent. Further, there could be a number of respondents where there's the statutory defence being advanced. So all of those involve cases where there are multiple respondents, and I'm not really going to go into those in any great depth or at all. What I'm really going to be focusing on here is where there are named respondent wrongdoers. So those could arise in situations of delegated authority, where, for instance, a manager is conducting a disciplinary hearing or the capability hearing, or there can be what's been seen in cases such as duty as tainted information cases, where the person who makes the ultimate decision has been misled to some degree by another manager who's not involved in the proceedings. So that's your curious owl. We're now looking at how So that's your curious owl, and we're now looking at how all these various claims can fit together. And you see I've set out in the slide the Equality Act, how the Equality Act goes about covering the situation of different respondents. You've got employers and employees, principals and agents, inducers and inducees, and knowing assistants. Now, causing or inducing also includes attempts, so it doesn't need to be successful. And I've dealt with, or I touched on a few moments ago, the tainted information cases. Here is a situation where a decision maker may have been misled by another manager. In cases where there are joint decision makers, then any of those people who are tainted could give rise to a discrimination claim. And if you look at the case of Reynolds and CFIS UK Limited, a case that I'll come on to in a bit more detail in a few moments' time, that's the sort of situation that arose there. Where it is a sole decision maker, whose own decision has been tainted by what went on behind the scenes, we see an interesting division there between the Equality Act and the Employment Rights Act, and we'll come on to when we come to the Employment Rights Act in a few moments' time. We'll be looking at what the Supreme Court in duty, how that has changed the law quite considerably. So we're looking now at tribunal powers to deal with multiple respondents, and the pre-2013 rules were much more limited as to the scope of dealing with multiple respondent claims. They required the possibility of a remedy being awardable against the individual, whilst the 2013 rules only require there to be issues between that person and the current parties. What the presidential guidance makes clear is that adding a second respondent is considered an application to amend, and so whilst there's generally no doctrine of relation back in adding claims, this principle does seem to apply to the substitution of respondents, and the case of Ryan and Bennington Trading is relevant there. It being an application to amend, time limits are a very, very important factor. And I think that if you are considering adding or removing respondents, then throughout the litigation process, parties should revisit who they have named and who is named at key stages. So pleadings, at the case management, at disclosure, at witness statements. I think that, as I say, at each of those stages, the decision or your mind should be applied to the situation of whether, or the question of whether or not you have the correct respondents added. If not, are you going to be applying to remove respondents, or are you going to be applying to add respondents? And it's very important because the CFIS case itself was an example of a tribunal not upholding a case that wasn't pleaded, which might not sound controversial, but throughout the course of that litigation it became apparent that it was a tainted information case and it hadn't been pleaded like that. And so what happened is, at the final hearing, the claimant failed in their case because they hadn't identified who the wrongdoer was. And in discrimination cases, as we'll see in a few moments' time, that is very important. You've got to be able to identify who did the discriminatory act, because in a case such as CFIS, which was a tainted information dismissal, it was found that the dismissal itself was a separate act to the provision of the tainted information. Now, the Metropolitan Police Commissioner and Denby decision says that CFIS should not be allowed to be used as a mechanism to escape liability for employers to escape liability where the claimant didn't know as to who was the appropriate wrongdoer in tainted information situations. So just looking at a few practical tips then, what do you need to ensure that you're best placed to be able to advise your clients appropriately? Well, firstly, if you're representing the respondent, you need a clear decision-making process. Are you able to identify from the documents, from the accounts given by your clients, who made the decision and on what basis that decision ultimately came to be made? If you are able to do that, then the second point is clear pleadings. You should be able to set that out nice and clearly for the benefit of the tribunal and the claimant when they receive your response. Both parties, I think, should not be afraid to use further and better particulars, seeking clarification of any lack of clarity in the pleadings. Don't be afraid to ask the difficult question of the decision maker if you're acting for the respondents. What did they know? Did they know of the protected characteristic? Did they know of the protected disclosures? Also bear in mind, both parties, that time limits are very, very important when making applications to amend, particularly if the real discrimination may have taken place many months before the dismissal. So a few practical thoughts. Do you need separate legal representation for yourself if you're representing the respondent and the named wrongdoer? It's a point we'll come on to a little bit later. And it may be that you only need separate representation for remedy. Particularly if you're representing the company and your initial view position is that there was no discrimination. If the tribunal then find that there is discrimination, then you might need separate representation on remedy if you're saying if the company is going to seek to push the blame onto the manager. Coupled with that is insurance. Do your directors need some sort of insurance protecting them and giving them an indemnity for any findings of discrimination against them? Moving then on to discharge of respondents. The tribunal's power to discharge a named respondent is very, very limited. They can only discharge under Rule 34 of the 2013 regulations where the individual was wrongly included. So there's no power to discharge if the respondent is correctly included and the claimant does not consent. It used to be, or it is considered rather, that if no remedy could be obtained against the named respondent, then they are wrongly included. In the case of Sandu, and the Department of Education is clear authority for that. One thing I'll come on to later when we look at the employee's defence is perhaps an approach that might be useful to those advising respondents to seek and to obtain the discharge of their named individual managers. How should claimants therefore go about gathering information as to who did what in the decision-making process? Well, firstly, they should, and many often do, seek to identify the decision maker and those other people involved in the process as early as possible. So subject access requests are a useful mechanism for that. Questionnaires, when they used to be a thing, were really useful for doing that. So then now they've been replaced by requests for further and better particulars and requests for further information. What should respondents do to assist themselves in the tribunal in understanding the case? Well, firstly, seek to obtain particulars of the detriments that the claimant is relying on. Also seek, a point we'll come on to in a few minutes' time, seek strikeouts of claims against named individual respondents or deposit orders. Don't be afraid, if you've got very clear instructions, to think about preliminary hearings on knowledge of protected disclosures or the protected characteristics. Equally, a point that I've touched on a few times before is preliminary hearings on time limits. There's also potentially, it's useful to consider whether or not you accept vicarious liability, put that in the pleadings, make the tribunal's job as easy as you realistically can when dealing with potentially complicated claims such as these. One of the particular tribunal powers that's been before the Court of Appeal recently in multiple respondent claims is the case of Sarnoff and XY and the tribunal power of disclosure. This all arises out of the Weinstein litigation, and Mr. Sarnoff was a named respondent who had never been to the United Kingdom, had lived on the west coast of America, but was named in employment tribunal proceedings over here in England and Wales. The Court of Appeal gave very short shrift to an argument by the respondents that the power for disclosure under Rule 31 was limited to the United Kingdom, which, in fairness, is what the rule itself says. But the Court of Appeal highlighted that Rule 31 was against any person, so it is wider than the parties, and the correct power of disclosure in multiple respondent cases is under Rule 29, that doesn't have any geographic location or any geographic limit imposed upon it. So no matter where you are, if you're named as a respondent, Rule 29 gives the employment tribunals power to compel disclosure with the usual sanctions. Now, whenever you're dealing with a webinar and you're looking for stock photographs and you type in law to any one of the stock photograph websites, you come up with at least half a dozen pictures of gavels. So I thought it only right that I put a gavel in when dealing with the slide addressing what claims. As I said at the very outset, really there are two main causes of action that involve multiple respondents. Firstly is any claim under the Equality Act. Here, dismissal and detriment are separate types of discriminatory acts. You can see them listed in section 39C and D in respect of employees. Either claims can be brought against the employer and or the employees in a personal capacity, see section 109 and 110, and the employer is going to be vicariously liable for anything done by the employee in the course of their employment, whether or not it's done with their knowledge or approval, and subject to what we're about to come on to in a few moments' time of the reasonable steps defence. The employee, the named individual employee, will be personally liable for any contraventions of the Equality Act, subject to the employer's defence. And again, we'll come on to that and we'll spend a bit of time in a few moments looking at that. And that offence is contained in section 110.3 of the 2010 Act. Now, for both detriment and dismissal, causation is the same. In each case, the tribunal will look at the reason why the individual acted as they did, and obviously, when it comes to compensation, injury to feelings may be recovered, whether or not the complaint is pursued against the employee or employer. Case I've referred to a few moments or a few times in the last few moments ago is the CFIS case. This was where there was a tainted dismissal, and the Court of Appeal rejected the composite approach of looking at the discriminatory actions of the respondents as a whole, and said actually they are separate acts. So the dismissal was a separate act from the provision of discriminatory information to the person who ultimately made the decision to dismiss. Feeds back, as I say, to being very, very clear, particularly in Equality Act cases, as to what you are saying the detriment is. Because you may have a wholly innocent decision maker at the capability proceeding hearing or at the misconduct hearing, who is blissfully unaware of the discriminatory information they have been provided to them by the line manager. Those are under CFIS and the Court of Appeal, those are separate acts and need to be pleaded as separate acts. And as I said earlier, in CFIS that wasn't done, and so the claimant was unsuccessful in their claim. Dealing then with whistleblowing and the Employment Rights Act. Time and time again we are warned not to port concepts from the Equality Act into the Employment Rights Act and vice versa. And we see that in, for instance, Kuzin and Roche, and Osipov itself said not to automatically port over Equality Act principles from CFIS into the Employment Rights Act. So we have a more complicated structure of claims under the Employment Rights Act. For instance, an employee may bring a claim under section 103, so unfair dismissal, against their employer, and a claim against their co-workers under section 47B for detriments that amounts to dismissal, which the employer may be vicariously liable for, subject again to the reasonable steps defence. Workers are in a slightly different situation, that they can bring claims under Part 5 for both dismissal and detriment. And the Court of Appeal in Osipov made clear that co-workers may be personally liable for detriments that amount to dismissals, and also liable for losses flowing from that dismissal, which was caused by a prior whistleblowing detriment. To make matters slightly more confused, under the Protected Interest or the Employment Rights Act and the whistleblowing part of the Employment Rights Act, there are different tests of causation. For unfair dismissal, it's the well-known test of what was the sole or principal reason for the dismissal, whilst for detriment short of dismissal, the test is whether or not the detriment was committed on the grounds of the protected disclosures. The case, again, I've referred to a couple of times and is well known, the case of Duty, went all the way to the Supreme Court. And in the Court of Appeal, King's Lord Justice Underhill gave 4 examples of employees and situations that claimants may find themselves in that called for an answer on the collective responsibility of employers. The first example that Lord Justice Underhill gave was that of an employee who just gave false information but wasn't in the position of authority. The Court of Appeal held that that was not a situation covered which would impute liability to the employer. The second example, which arose in Duty itself, was where a line manager for Miss Duty gave gave information that was untrue to the manager, who ultimately dismissed Miss Duty on the grounds of, and that information was a detriment on grounds of making a protected disclosure. In the Court of Appeal, that was held not to have been sufficient to impute liability or import liability rather onto the employer. The third category is where there was a manipulator has a formal role in the process, and that was held to be covered by or to impute liability to the employer. And finally, where the manipulator is at the top or near of the hierarchy but has no role in the process itself, that was held to also be covered. So the case moved its way to the Supreme Court, and the Supreme Court found that the last of those 3 approaches, the final 3 of those approaches were covered and were sufficient to impute liability or report liability onto the respondent. So it is a composite act approach in those circumstances. So we've got a line manager who's not involved in the process. We've got someone who's formally involved in the process, and someone who's at the very top of the hierarchy but takes no formal role. They are now sufficient to impose a composite act approach on employers, and liability will therefore shift to them. So what can employers do to assist themselves and defend themselves? Under Section 109.4 of the Equality Act and 47B(1)(d) of the Employment Rights Act, there is a defence for the employer. However, there are 2 major points we need to raise. At the outset. Firstly, that this will result in a conflict of interest between yourself or between the employer and the named individual employee, because the employer is saying that all reasonable steps were taken, and this is the second point, in advance of the discrimination or in advance of the protected interest detriment, to ensure that the named individual employee did not commit the act. So please do be aware that if you're advancing this defence, conflict of interest will arise between the employer and the named individual employee. So how do you go about mounting this defence? Well, it is notoriously difficult to succeed on. First, and what follows now are just some points that appear, I think, are useful to bear in mind when considering your prospects of success on this defence. Firstly, any policy you have must comply with any relevant codes of practice. So, for instance, on harassment, on protected disclosure, those sorts of things. The policy must be clear. It must identify what is considered as unacceptable behaviour. It must provide mechanisms for raising complaints, so speak up lines, those sorts of things. It must give guidance on how to question complainants appropriately. It must be readily accessible. It must guarantee strict confidentiality. It must be a living document. It can't be just a document you have sat on a communal drive for years on end and never really being looked at or updated. It's got to be widely disseminated. It should be part of a package of policies. So if you were dealing with, an Equality Act harassment policy, you should have your Speak Up policy, you should have an Equal Opportunities policy. There should be training, there should be evidence that the perpetrator had read it and had received that training. Training shouldn't just be limited to shop floor staff. Managers should also have training as to how to deal with harassment or discrimination when they spot it, and it's got to be up to date. Very recently, the Employment Appeal Tribunal in LA and Galen looked at how often training should be given and whether or not it is a relevant factor, how effective that training could be. The Employment Tribunal found that effectiveness of the training was a factor to be considered when thinking about other alternative methods of training to ensure compliance with the Equality Act. The point went on appeal, and the EAT rejected the appeal on the basis that clearly effectiveness must be a factor to be borne in mind when you're considering whether or not all reasonable steps have been taken, because if you're offering training that is not effective, then chances are there's going to need to be other training that's put into effect. In LA, what happened was there was training a couple of years ago before the incident, and there's a large number of racial comments made to Mr. LA. And managers heard them, other members of staff heard them, and no one did anything about it. The employers, when litigation ensued, tried to advance the employer's defence and were unsuccessful, partly because of the reasons I raised earlier. Also, do bear in mind whether or not if you are advancing the employer's defence, whether or not it's inconsistent with your primary defence of it never happened. It doesn't look good that you say it didn't happen, but if it did, we did everything we reasonably could do, because that might indicate you don't actually know what the situation is. So we come now to the employee's defence, and this is contained in section 110.3 of the Equality Act and section 47B(1)(e) of the Employment Rights Act. And it doesn't result, I think, in a conflict of interests between the employer and employee. In high-level terms, what the defence is that it was the employee went and sought advice from the employer. The employer gave that advice, and it was reasonable for the employee to rely on that advice. Now, obviously, this is only going to be applicable in certain types of discrimination and detriment claims. So, for instance, if the case was one of harassing jokes in the crew room, then it's unlikely that defence is going to have any prospect of success, because if the employer is giving advice that it's okay to make racially harassing jokes in the crew room, then you've got all manner of problems with your HR team. But I do think it's a real opportunity for respondents in cases where it's delegated authority. For instance, there's a dismissal or a sickness absence case. For an employer to say, look, we put our manager up to run this process. The manager was in contact with HR constantly throughout the process, and we gave them advice, and clearly it was reasonable for them to rely on that advice. I think that if you set out that in your response and then send a letter to the claimant saying, look, we're not seeking to escape liability, we're not insolvent, We ask you, therefore, to voluntarily allow us to, or allow the tribunal to discharge the named individual respondent. If the claimant refuses to do that, then I can't see why seeking a preliminary hearing on grounds that we discussed earlier, and or strikeout or deposit order to be issued against the claim against the named individual respondent. Now, I've yet to see this being taken. And my research and speaking to members of chambers, none of us are aware of any case law and appeal case law on this point. So it does, I think, really have open ground in front of it if you are going to, and you've got the situation where your named manager has taken advice on HR and has followed that advice. I say it certainly has a benefit to the employer with a small p grounds, that managers see that their employer is standing behind them and is seeking to assist them. Also, it removes the undoubted stress that named individual respondents face when they see their name on court proceedings. The final issue we're going to deal with quite briefly is compensation. Under the Employment Rights Act, compensation against employers is calculated on the basis of what is just and equitable. See Section 123(1), the compensatory award, and Section 49 of that Act that deals with compensation for whistleblowing detriments. In a claim by an employee against an employer, the two are, however, mutually exclusive. Compensation for unfair dismissal is limited to post-dismissal losses, whilst detriment is limited to pre-dismissal losses. Case of Media and Magna Kensei sets that out. So you do need to be able to clearly identify what you say it caused, the particular loss that you're claiming. In Osipov, the Court of Appeal said that where there was a distinct prior detrimental act done by a co-worker, which is broadly defined, and that results in the whistleblower's dismissal, the whistleblower can still recover compensation for losses flowing from the dismissal, subject to rules of remoteness and quantification of loss. So you cannot bring a claim against a co-worker for unfair dismissal, but you can bring one for pre or post dismissal detriments. Now, the advantages for the claimant is that injury to feelings awards are available for pre-dismissal detriments. There's a substantially lower causation threshold, so material influence rather than the principal reason. And you have the potential recovery for damages from the co-worker where the company, for instance, is insolvent or has been dissolved. The disadvantages for the claimant for seeking compensation against named individual respondents are reinstatement or re-engagement is not available, a basic award is not available, and the employer has the potential for the reasonable steps defence. Turning now to claims under the Equality Act. Here, wrongdoers are jointly and severally liable, and there's no power to apportion that wrong or the compensation between wrongdoers. See the case of Sivanandram. But where harm is caused by different acts, and those acts of discrimination, and they can be divided, then the tribunal does have power to apportion liability and compensation between the wrongdoing parties. So that's really, hopefully, half a dozen or so points that you need to bear in mind when dealing with multiple respondent cases. I hope that this has been a useful webinar. I apologise again for those of you who attended the webinar at the end of March for the technical difficulties. I hope I've ironed those out. And if you have any questions, please don't hesitate to drop me a line in chambers or send me an email, and I'll see what I can do.